A very good day, madam. This will be our group presentation for our title, The Effect of Awareness of Unfair Dismissal Among the Employees. Okay, the group member will be four of us, including me. Hi, me Nantini, and then there will be Nawara, Zulaika, and Sharifa. Okay, let's start our presentation. Okay, introduction. What is unfair dismissal? Unfair dismissal in its simple form is termination of employee contract and no reason for the employee's firing. It is also possible to claim if the employer was justified by the dismissal was dealt with utilizing the wrong procedure. An employee is someone who trains and pay for the employment, which is used to support the business. An employer normally ends the employee's work contract after an employer has been rejected. In the case of wrongdoing, poor participation or violence, for example, the employer may prove fair to the employee. Automatic unjust dismissal is a word used to describe certain cases where a worker has been dismissed for a certain cause protected by law. The main objective of this research is to discover and measure the effect of awareness of unfair dismissal among the employees.
So this is our objective for this study. So firstly, to educate ourselves on the law relating to unfair dismissal. Next is to give exposure on how a firm should engage in human resource management practice, particularly when dealing with workers whose performance is unsatisfactory. Other than that is to provide comparisons of individuals' awareness and knowledge of different groups of rights. Then is to examine the extent to which difference in level of knowledge and awareness can be attributed to individual characteristics. So this is our literature review. So the term awareness was defined as a person who is sufficiently informed about a subject to be aware of its existence and broad subject matter. In this sense, knowledge of an employment right or law implies that the person had heard of it and had some understanding of the area of work to which it applied. According to a survey by Favre, Raff and Nichols, Theo and Pryor et al. 2009, employers are important in determining whether employees are well informed about their rights. This survey attempts to measure general awareness of employment right by asking, firstly, how do you feel about your right at work? In general, 78% of those polled said they were either very well informed or well informed about their right at work. 9% very well informed about unfair dismissal. Miguel, Nigel, and Thiers et al. In 2002 explained that 78% of workers sought employment law assistance on unfair dismissal issue. 7% of them did nothing, and 15% resolved the issue on their own. However, according to this study, the majority of workers are aware of unfair dismissal law. However, Blackburn, Robert, and Hart and Mark in 2002 explained that a worker's understanding of unfair dismissal law is very important. Employers who are knowledgeable of the legislation, for example, indicate that they know how to advocate for their employees' right when they are. In 2021, Al-Harbi MN explained understanding employers' level of awareness and knowledge of unfair dismissal rules actually can help evaluate reports of unfair dismissal law effects based on perception or experience. Friends B and Oslington P in 2007 also stated that employees who are informed of their law on unfair termination will be better equipped to defend their right as employees. So this issue can be brought to justice if all workers are aware of unfair dismissal law and workers will be given their rightful rights. According to Friends BP, Oslington and Oslington P in 2021, unfair dismissal law is critical because it aids in the fair resolution of issue as redundancy payments and deferred value of expected income. As a result, Researchers believe it is critical to analyze the proposed unfair dismissal provision separately from the other proposed modifications, as one change may be unsupported by evidence, while others have a significant impact on employment outcomes.
This is the conceptual framework that is associated with the topic of this research. Employees' relationships are influenced by a variety of circumstances. Scholars have developed many methods to industrial relations, such as the unitary approach, the pluralistic approach, and Marxist theory, to provide rules and argue legitimate reasons for managing employee rights at work. The approaches, however, convey various perceptions to management, such as aspects of work societies and organizational structure. So both unitary and pluralistic models immediately address the issue of wrongful termination of employment. The management and all employees share a set of common values, interests, and organizational objectives, and the unitary approach sees the organization as a single unity and one happy family. The approach also implies that even in the absence of serious causes, trade unions are not required to intervene in unjust dismissal of employees. Furthermore, dispute is seen as a fabrication that is not destructive, and collective bargaining is seen as antisocial. The model takes a paternalistic attitude in which it expects employees to be loyal. Pluralistic approach, on the other hand, emphasizes the necessity of trade unions because power is believed to be pervasive and conflicts are rational and unavoidable. According to the Marxist viewpoint, class conflict is essential for social transformation to occur. The worker class reacts strongly to social change, and the gap between the economically settled owners of factors of production and the economically dependent working class is closed. Pluralism is viewed as unreal, and industrial disputes and class conflicts are viewed as unavoidable for an industry's circular functioning. So the majority of employees are still struggling for their own rights against management. Their expectations are still in the hands of trade unions. On the other hand, all of one's efforts and expectations are in waste. Employees' rights are still being violated as they have a limited ability to negotiate collectively, their freedom of expression has been taken away, and they are left with their complaints and grievances. The employee has the right to reinstatement under Section 20 of the Industrial Act. If conciliation fails to resolve a claim for reinstatement, the Minister of Human Resources must decide whether the matter should be referred to the Industrial Court for arbitration or not, according to the Industrial Relations Act. Aside from that, the Minister is required to send the issue to the Industrial Court if there is a potential that the employee was fired without reasonable cause, as the employee is normally given the benefit of the doubt. In addition, if the employer is dissatisfied, they can file an appeal with the High Court to have the Minister's decision overturned. Only workmen can file a suit under the Industrial Relations Act of 1967. Any person, including an apprentice employed by an employer under a contract of employment to work who has been fired, dismissed, or retrenched for hire or reward in relation to or as an outcome of that disagreement, or whose dismissal, discharge, or retrenching has caused that disagreement, is referred to as a workman for the purposes of any proceedings in relation to that dispute. As a result, it only applies to service contracts and all workers working legally in Malaysia, including Malaysians and foreigners, but not to employers in the public sector. Employers in the public sector, on the other hand, have the option of taking their case to the High Court. The right not to be unfairly dismissed is meant to function as a restriction on employers who have the ability to recruit and fire as they want, according to the Industrial Law Journal 2015. According to Philip J. and Sons, the term unfair dismissal is not a common sense statement that the average person can understand. The ERA 1996, as modified, contains the current unfair dismissal legislation. Under the EA 2002 and associated rules, new statutory dispute resolution processes are introduced, encouraging parties to avoid litigation or utilize the new alternative ACAS arbitration procedure. Because the emphasis in unfair dismissal cases is very much on the particular applicant situation, the right not to be wrongfully fired is arguably the most basic. Aside from that, the tribunal in its position as an industrial jury should be the final decider of an employee's conduct. Every employee has the right to be treated equally by his or her employee under Section 94(1) of the Equal Employment Opportunity Act of 1996, even if the employee offers to pay the maximum compensation recoverable with no acknowledgement of wrongful dismissal. An employee has the right to have an unfair dismissal complaint heard before an employment tribunal. The claim is for more than just monetary compensation. It is an allegation that the firing was unjustified. The employee is entitled to a decision on the subject as well as the right to pursue his claim in front of the tribunal for that reason. In an unfair dismissal complaint, the applicant's formal burden of proof is to establish the fact of dismissal under Section 95, whether express, implied, or constructive dismissal. The respondent, the employer, must demonstrate that the reason for dismissal is covered by the statutory reasons for dismissal. The heart of unfair dismissal law is statutory reasons for dismissal, Section 98, ERA 1996. The research design of the study is quantitative research methodology, in which the focus of this study is to explore the effect of awareness of unfair dismissal among employees. Self-administered type of survey was chosen to administer by the researcher. The survey is carried out online through Google Form and is spread by using social media platforms such as WhatsApp. The Google link has been given to 30 respondents via WhatsApp. A friendly reminder is given towards respondents to read the instructions carefully before completing the survey and indicating that their participation is voluntary in the study. Besides that, the researcher has stated that the data that is obtained from the survey are confidential and will be published in the results of the study as an aggregate data. Once the survey is completed, the researcher thanks the respondent for their cooperation and willingness to complete the survey. Last but not least, the data obtained will be analyzed using the Statistical Packages for Social Sciences, or SPSS software version 22. The questionnaire provided in the Google form is divided into two parts, which are part 1 is the demographic information, and part 2 is the effects of awareness of unfair dismissal among employees, in which consists of 10 items. The scoring of these items is based on 5-point Likert scale, which is strongly agree, agree, neutral, disagree, strongly disagree. The result obtained from this survey will indicate the frequency of the effect of awareness of unfair dismissal among employees by the respondents.
Then the descriptive analysis, we use the respondent's gender. This table indicates that the frequency of the female is higher than the male, which the female got 21 respondents while the male just got 11 respondents, which show a moderate valid.
So this part will consist of the discussion of findings in research based on the data analysis in the previous chapter. So in this previous chapter, the reliability test was run to discover and measure the effect of awareness of unfair dismissal among employees. As the data sample were only 32 respondents, which includes 11 male and 21 female, this may cause the results to not be fully accurate and reliable to generalize the findings to the whole population, and the result of reliability test is only 0.729 and moderate and quite low. So however, through this result, it can be conducted that and concluded that the occurrence of awareness unfair dismissal does not occur differently among employees, and into a more specific finding, the respondent of unfair dismissal in their workplace, which may influence the findings of the reliability test in this study. So through the findings, results that were obtained from this study are slightly similar to the past studies that have been done by other researchers. So even compared to the literature review, the findings towards the awareness fair dismissal among employees are similar. So for the limitation of study, lesson learned, it may be possible that other factors affect unfair dismissal greater than the awareness of employees. However, in this study, the limitation of study is the number of data sampling, which is not reliable and valid to be generalized to the population, as it only holds 32 numbers of respondents. Also, you can see that the state of origin among respondents is not focus on a few states and did not cover the entire states of Malaysia, and 32 respondents doesn't cover that. And you can also see the industries that we focus are not too specific. So for the recommendation for the future studies, future researchers might want to consider the number of data sampling to obtain a stronger result. So there's a lot of dimension for awareness and also knowledge that might need to be considered, which may affect this issue. And this is because it may be a high possibility that unfair dismissal has its effects towards some of the dimension. So instead of the whole dimension of awareness unfair dismissal, researchers can also consider on expanding the field of study into other industries. So for example, researchers can look into what kind of industry they want to focus on, and what kind of goal they want to look into, so they can get more accurate study. So to wrap up, the results of the present study are related and support the results of past studies that have been done by other researchers. So, however, there are few aspects and factors to consider in future studies. It has been overlooked in the present study. So inshallah, probably if there are researchers out there who wants to take this study into, more deeper understanding, probably us, who knows, inshallah. So maybe it can help the future of employees in Malaysia. So are you aware of the things that have happened in your company? Have you completely understand what does it mean to have the rights of your own as employees? So if you don't, make sure you step up your game and don't let your employers fool you. Thank you for your undivided attention and listening to our presentation.